Well, welcome. I want to thank you both, Sharon and Ken, for choosing me as your mediator today and for agreeing to appear here. I understand from the terms of your contract that there is an ADR clause in place and that you have chosen mediation today to try to resolve the dispute that is in front of you. A little bit about the process today. You are working under the ICC mediation rules, and the parties have requested that our mediation remain confidential today. Is that right?
Yes.
And that's fine. Anything that you say here today will remain here today. If I take any notes, I'll destroy them when we're done, as long as everything comports with local rules under the ICC. So I don't anticipate any problems with that. So you should feel free to speak frankly with one another.
Okay.
A little bit about the mediation process, as you're both attorneys, I'm sure you're familiar, but I am here to help you with the process, and the two of you are responsible for the product. Any agreements that you reach today are ultimately the responsibility of the attorneys and the authority your clients have given to you. So I'm not here to make decisions, I'm not here to make suggestions, I'm here to make sure the process runs smoothly and that you both get a chance to say what you came here to say. If there is a possibility to reach an agreement today, we might write that up, but again, that is up to the two of you and how things proceed. I might from time to time check in and make sure that we're moving along as, that we're using the time as efficiently as possible and that we're talking about the things that you came here to talk about today. And if I feel like the process isn't productive, I might ask that we meet separately. I would meet with you, Ken, and then I would meet with Sharon or vice versa and make sure that we each have a chance to, you can speak freely with me if you feel that that would be helpful, and you could also request a caucus if you feel like that would be helpful today. All right, before we begin, I would just like to remind you that because I'm not a decision maker, you don't have to convince me of anything today. So really you're here to talk openly with each other, and so I encourage you to talk directly to one another as much as possible, and I'll give everybody an equal chance to share what brought you here today and what you think might be helpful moving forward. So, Ken, I understand that your client is the one who has made a demand and requested a response from Sharon, is that correct?
Right.
Okay, so why don't we start with you and you can just tell me from your perspective what the issues are that you would like to resolve here today in mediation.
Sure, thanks, Lynn. And first of all, I appreciate, Sharon, your agreeing to come. Lynn, for your information, I'm in-house counsel for Shenzhen Nouveau. We are a high-tech manufacturing company with our headquarters in Shenzhen, China. About 6 months ago, we entered into a contract with Zig Incorporated. It's an exclusive manufacturing contract to produce both hardware and to install software related to some technology that Zig created to produce a tablet scanner. And Sharon, I just want to mention to you that we have enjoyed working with you. It was a very good negotiation to create this business relationship. We look forward to resolving this in an amicable way so that as we move forward, we will continue to have an ongoing and good business relationship between our two companies. One of the provisions of this exclusive manufacturing agreement is a provision in the event that that Zig Incorporated were to produce or develop similar technology or new technology related to what is covered under our agreement, and specifically it's provision 17.2 under the contract. And that provision provides, it's pretty straightforward, that during the term of this agreement, and we are under a 1-year agreement, we're about 5 months into that agreement, that in the event that during the term of the agreement, Zig requires the manufacture of any new product or manufacturing, including but not limited to tablet scanners, that they're more than welcome. They're free to solicit bids from any company that they choose. But because we are already in a contractual relationship to manufacture this kind of product for Zig, that pursuant to the contract, we would be given an opportunity to review whatever bids they receive for this new technology or this new product development, and we would have an opportunity to submit our own bid. And in the event that we are successful in submitting a bid that exceeds the requirements of any other competing bid, that the business would come to us. And frankly, that makes perfect sense because we have worked very hard together. This is a new product area, and we recognize the intellectual property of Zig Incorporated. But quite frankly, Shenzhen brings to the table the expertise in translating ideas into products that can be sold to consumers. And we have invested a great deal of time and expertise in helping Zig through the beta testing phase of our relationship, and we're now moving into the full production phase where we've made a significant investment in this relationship, where we now have particular expertise related to tablet scanners and specifically related to turning your proprietary knowledge into saleable products. And so it only makes sense that during the term of this contract, we be given the opportunity to compete for any new business that's related. And frankly, that's why there is this contractual obligation to do so. We learned recently that Zig has approached another company, Noki, with a very similar product. And this product, instead of being for a tablet scanner, this product would be for smartphones. And quite frankly, the only difference between a smartphone and a tablet scanner is the size. Everything else is the same. And so from our perspective, they are taking the technology that they have agreed we would manufacture for them, and they're now seeking a different platform and outlet for that same technology. And it's very clear under the terms of the contract that we have the right to present a competitive bid to manufacture those new products. So that's why we're here.
Okay.
But,
Thank you.
But actually, just finally, to go back to my initial comment, we believe that we have the right to do this, but we also want to be able to do this because we believe that we will be able to demonstrate to you that we really are the partner you want to be working with moving forward. And we do not want to be prevented from having that opportunity to prove the value that we really offer to you.
Thank you, Ken. I appreciate that. And I'm sure, Sharon, that many of the things that Ken said you agree with and many of the things you might see differently. And so before you respond to what he said, I'd just like to give you the same opportunity to tell me from your perspective how you and your clients see things.
Thank you, Lynn. I appreciate that opportunity, and I also am very hopeful that we can reach an amicable arrangement here today. I think that's really in the best interest of our companies and moving forward. And as you said, much of what Ken has said, I agree with in terms of the background of how we entered into the manufacturing agreement between Zig and Shenzhen. And the beta testing has been going well. We are fully confident that the production piece of it will go well in addition. Where we differ on our perspective on this is what exactly is the nature of what we have entered into with Noki and seek to enter into with Noki. This is not a new product. And the solicitation terms refer to new product manufacturing. The telephone is the product. That's Noki's. That's not ours. So we don't view this in any way, shape, or form implicating Section 7.2 or 7.3 or 7.4 for that matter. This is an independent right that we had. We would not have entered into an arrangement that would have restricted Zig in the way that Ken is suggesting that we would. So we really fundamentally see this as a very different question in terms of what it is that we were seeking. This is not a new product. It is merely a subsystem Noki will be producing the product, that's the phone. And so we don't really understand and don't expect that that's anything that we need to offer Shenzhen to be making a bid on. We didn't need to share Noki's anything that we have had with Noki. And so we're in a position where we feel like we have done every piece of what is required under our exclusive manufacturing agreement. If push comes to shove, I would suggest that what Shenzhen is doing right now is interfering with our right to contract independently. And so, you know, we don't want to go there, much as we don't really want to go here. But we believe that if they were to pursue this kind of a claim, we could come back with a counterclaim that in fact it's Shenzhen who is violating our exclusive manufacturing agreement. Again, I am hopeful that there is something that we can work out so that we don't have to pursue these legal remedies going forward.
So before we go back and forth with asking each other some more questions, what is it that each of you hopes to accomplish in our meeting today? Is it something that you want to redraft the contract or just flesh out what the issues are? What are your hopes for our time here today? And I'll start with you.
Well, we spent a great deal of time negotiating and crafting the agreement between the two companies. And I think that by and large, it's serving both of our companies' interests quite well. So there's no need to be redrafting anything. From our perspective, the language is clear in the contract. And from our perspective, both the letter and the spirit of the contract would encompass the kind of activity that ZIG is describing as independent from the contract. So our interest, of course, is to preserve our working relationship because we have a very good one. But from Shenzhen's perspective, we have an obligation to protect our rights as well. And I appreciate what you're saying, Sharon, that you don't want push to come to shove. Neither do we want push to come to shove. And we're confident, first of all, that the interpretation of the contract would fall in Shenzhen's favor. And we're further confident that our right to enforce a contract provision in no way creates any claim for interference in contractual relations with any third party. So I appreciate what you're saying. I respectfully disagree. And we would like to avoid having to fight that issue out, whether it's in arbitration or if it went to domestic court. But we're prepared to do so if we're not able to reach an agreement today.
And again, you know, I feel equally confident that we are not going to be found to have been in breach of any of the agreement that we've made with Shenzhen. So again, it's not where I want to go, but I'm not afraid if we were to pursue this in a more formal setting where there's going to be a decision maker. I feel very confident that the language of what the exclusive agreement, manufacturing agreement, will stand up that what we're talking about with Noki is not a product as was envisioned by that the language and the clauses in the agreement. So, you know, I am hoping, Lynn, that you are going to help the two of us and our companies figure a way out so that we don't have to pursue it. Yes, we both feel confident we could prevail, but perhaps that's not the best use of either of our company's time and resources to go there.
Right, and I agree. I think at the table today, we're not here to litigate the matter. We're not here to dissect the terms of the clause from a judge's perspective. What we are here to do is figure out if there's a way that you can both get what you need. It sounds like both of you have enjoyed the relationship thus far, that the beta testing has been going well. Mm-hmm. Given what you each heard from each other, do either one of you have questions about where things stand in terms of the production of the tablet scanners or the production of the phone scanners? I'm not sure where that is along in the process.
Well, I'm curious, and I don't know whether you have this information, Sharon. With respect to the tablet scanner, from our perspective, everything is moving along well. We had the expected problems, but that's what beta testing is all about, and I think we've overcome them and we're moving forward. What I'm not sure about is what the timing is with respect to any offers that you have received from Noki, and whether that's imminent or whether there is time for us to work this through. My hope is that we are not put in an artificially short time frame where we are forced to play hands that we would rather not play. So I'm not sure if that's a fact question to you, but or more of a statement in terms of our process. I would hope that we are able to play through whatever the mediation process provides or otherwise, so we can reach a resolution before any other external timelines run out that complicate things further than they already are.
Yeah, without getting into the specifics of it, we are able to enter into some conversations today that I think we've got the time to do
Okay.
that.
Okay.
We don't have unlimited amounts of time, but we certainly have some flexibility as of today.
Okay.
So in terms of our time here today, are there constraints in terms of how long you have at the table today so that we can ask a few more questions, or is it something that we need to get sort of to the heart of the matter rather quickly?
Well, we're here to seek a resolution, and on behalf of my company, I'm willing to stay at the table as long as we're making constructive progress. Whether that's 1 hour, or 30 minutes, or a longer period, that remains to be seen.
Okay. So what I heard you say, Ken, is that your company is interested in preparing a bid based on the bids that have been received by Noki. Am I understanding that right?
Well, what we would like to do, I mean, and this is not us, this is the contract. Pursuant to the contract, we have if Zig is seeking to enter into another relationship with a third party to manufacture products similar to the tablet scanner, we have a right to see what they are seeking a bid for so that we can offer our own competitive bid, and to have the opportunity to either meet or exceed the requirements of the bid that they've received. That's all we're asking for, is to be able to do that.
And from what I'm understanding from you, Sharon, is that you do not feel, or your client doesn't feel, that this is a new product that falls under the terms that would require.
Right, it is not a new product, and there's that's really a stretch of any definition that would be a product. This is merely a substructure.
Okay, so hypothetically, Ken, if we go down the line that Sharon is suggesting and we say that this is a substructure, what is your understanding of your client's position about that? What does that look like? If just for argument's sake, we take Sharon's view of things,
okay.
Then what would your client expect to have happened?
Okay, well, our positions, I think, are pretty clear. Zig believes that what it is seeking a contract to produce is not a product, and we are very clear that it is a product. My understanding is that Zig believes that what they're seeking manufacturing for is not a product because it is not the end product, but it is a subsystem. Our view is that products do not exist only for consumers. Products also exist at a wholesale level, and they also exist between business and business. And when you are manufacturing a complex item like a smartphone or a tablet computer or a car, there are many subcomponents that need to go into it, but each one of those is an independent product. So from our perspective, it is in fact a product. So we've done our research. We're confident that a domestic court would find in our favor, but If it were not a product, then I would agree with what Sharon is saying. We're confident that no court would reach that conclusion.
Right. So I feel like we are sort of having the same kind of conversation. It's clear that you both believe very strongly in the position that you came here with today. So I wonder if it might not be more helpful for us to meet independently and see if we can kind of get at what might move us forward.
I think that'd be very helpful.
Okay,
That's
so
fine.
if you don't mind, Sharon, I'll speak with Ken for a few minutes, and then we'll come and get you, and I'll speak to you at that.
Sure.
Okay.